Hello, everybody, and welcome to this Ciarb webinar on adjudication for low-value disputes. The full title, in fact, is Low Value Adjudication: How can adjudicator nominating bodies better cater to smaller disputes? My name is Lewis Johnston. I'm Assistant Director of Policy and External Affairs at the Chartered Institute. And I'm delighted to be presenting the second in our occasional series of adjudication webinars, where we seek to explore some of the most live issues in adjudication and really draw on the knowledge and experience of some of the leading experts in the field to see what the future of adjudication might hold. Some of you may have joined us for our first webinar just over a month ago, which was a retrospective on 25 years since the introduction of statutory adjudication in the UK. There was a fantastic discussion there, and it was great to hear from all of our audience members. And we're building on that now because one of the main themes that came out of that session was low value adjudication. This is obviously a live issue. Particularly with the introduction of the CIC low value dispute model adjudication procedure last year. There's a lot of debate and conversation around the particularities of lower value disputes and how adjudication can serve them, and how the process of adjudication itself may have evolved in ways which means that low value adjudication has to be seen as a separate category. Today, we're going to explore a little bit about how adjudication and other forms of dispute resolution are perceived by smaller parties. We're also going to look at how the CIC low value procedure has fared since it was introduced last year. And then we're going to look at a bit more detail at how adjudicator nominating bodies can perhaps boost understanding and knowledge of the options that are available for catering to smaller disputes, and how the actual process might need to be streamlined further in order to manage those costs, because that's obviously a big priority. I'm delighted to be joined by such an eminent panel of speakers today. Firstly, we are joined by Marcus Cato. Marcus is a fellow of the Chartered Institute and is honorary secretary of the Southeast branch, co-chair of the Ciarb Board of Management, and non-executive member of the Rwandan branch committee for Ciarb. He has over 25 years experience in international construction and engineering disputes resolution, practicing as a certified commercial mediator and a qualified arbitrator. Next, we're joined by Peter Colley. Peter is a dual qualified construction professional and barrister, and he has 40 years experience in the construction industry and working as a legal advisor around the world. He's been appointed to the FIDIC contract committee responsible for drafting the suite of FIDIC contracts, and also is involved with the Chartered Institute of Building ADR committee. So it's great to be joined by Peter. Next, we're joined by Hayley Lorimer from the Federation of Master Builders. Hayley is Director of Membership Services there. And the FMB represents a membership of 7,500 smaller and medium-sized enterprises within construction across the whole of the UK. And we hope to hear from Hayley with a bit of insight on how FMB members, particularly, which obviously represents the smaller end of the sector, perceive dispute resolution and where their level of understanding of the options that are available to them lie. And last but not least, we're joined by Matt Malloy. Matt is an experienced dispute resolver and has been appointed in over 800 construction and engineering disputes as either adjudicator, arbitrator, mediator, expert determiner, or conflict avoidance panel member. These disputes have concerned a number of high-profile projects both in the UK and overseas. Matthew's on the RICS, TEXA, Ciarb, CEDA, CIC, CIOB, and REBA panels of adjudicators, as well as the Irish government panel of construction adjudicators. So it would be great to to hear his insights into low value adjudication. Just a quick bit of housekeeping. We do welcome questions from our audience members. You will see, hopefully, on the Zoom function, you've got the Q&A function at the bottom of your screen. So please feel free to submit your questions there. There will be a dedicated section towards the end of the session when we will focus entirely on audience questions. But please do submit your questions throughout the discussion as well, because we may be able to bring those into the debate. And it'd be great to hear from you. Also, within the chat function, we do like to hear who is joining us and where from. So please do share that. I see some of you are already doing that. So without further ado, I will actually start the discussion, and we can start hearing from our panelists. So firstly, I wanted to address this question of why smaller disputes, why it makes sense to see them as a category of their own, why they face particular challenges when it comes to dispute resolution, and why it was felt that adjudication as a process perhaps wasn't fully catering to the needs of those lower value disputes, the particular needs to manage costs and yeah, keep a cap and certainty on that. So Matt, I wanted to bring you in at this point and just ask you to give us a bit of context and background, particularly around the CIC scheme when it was introduced last year.
Yeah. Good morning, everyone, and good morning, Lewis. Yeah, I think the one of the sort of characteristics of adjudication 20 odd years on from its introduction is that it's matured into quite a complex process, and with that has come a level of expense. And we started to hear noises, I think, around the consultation of the review back in sort of, which resulted in the 2011 amendments. And some of the noises were basically that this adjudication is now out of the reach of firms who want to have relatively low value disputes resolved. So I think there was a perception that if you had a dispute for, let's say, £20,000 or lower, the risk and cost associated with having that resolved was such that it wasn't worth the fight. And that led to disquiet. And so in terms of how the CIC approached it, and this predates my involvement with the CIC. I'm now chair of the CIC ADR Management Board. But the person who was previously in post consulted with the members of the CIC ADR Management Board and said, well, what can we do? And they looked at it from the cost of the adjudicator and also the cost of the party. So the catalyst was process too complex, too expensive, can we do something? And what they came up with was the CIC low value disputes model adjudication procedure, which sought to impose a limit on the extent and volume of submissions that could be made, and also to which should have, in theory, an impact on the costs of running the adjudication, but also to impose a limit on the fees that the adjudicator could charge or recover. And there's a sort of a sliding scale of fees, and they pitched it. The CIC pitched the value of disputes that could qualify for its adoption at 50,000, and then there's a sliding scale down to I think from sort of below 10,000 up to 25,000 up to 50,000, and they seek to cap the adjudicators' fees to sort of reflect the size of the dispute. So that was the if you like, that was the motivation for its introduction. And there are other, there are other models out there. So the Technology and Construction Solicitors Association, they have a low value adjudication procedure, which in their, I think their category of low value or definition of low value actually goes up to 100,000. But again, they have it's a different type of model, but the idea is that there's a cap on the fee of the adjudicator. So yeah, I think that answers your question, Lewis.
Absolutely, thank you, Matt. What I'm particularly interested to understand a bit more as well is the way in which smaller firms in construction understand what mechanisms and what options for redress are open to them. Obviously, adjudication was introduced to provide a statutory right to that process and that means of obtaining redress. But there is some evidence that that the understanding of that, particularly with smaller firms, is perhaps limited. And Hayley, I wondered if I could bring you in at this point, particularly in light of the FMB research, which I believe you have some figures on perceptions within your membership.
Yes, indeed. Just by way of background to that, Lewis, we deal with about 400 dispute cases every year where our members are in dispute with a client, and for the most part, almost all of those cases actually are domestic clients. So they're not commercial or industrial clients. They're people who've had building work done on their own homes. And we did conduct a piece of research in March this year with both clients who'd used the service and our members who'd used the service to find out how effective the service was being. Because we resolve those disputes through informal mediation. We're aware that they all are low value disputes, certainly by the definitions that Matt's just talked about. They certainly would fit into the low value category. But within that, there's quite a lot of diversity. And so we're kind of using one service to try and resolve all of those different types of disputes. So when we surveyed them, we found that both the clients and the builders had a very low awareness of ADR as a whole before starting down this process, because I think they don't really give much thought to how they'll resolve a dispute until it actually happens for them. So they weren't aware of the different types of ADR and the implications of using one service or another. And even members who are members of our organisation, of which dispute resolution service performs as part of the membership package, weren't aware of our service. About half of our members weren't aware of our service until we contacted them. So at that point, obviously everybody's very upset. The clients have had work done on their home and aren't happy with it. So their home has been jeopardized, perhaps to some extent in their minds. So that's not a good time to be introducing new concepts to people who aren't aware of them, such as alternative dispute resolution, adjudication, etc. So we would say that awareness is very low overall. We also had some stats shared from the government department BAYS recently that said that only 16% of the consumer market as a whole is aware of the existence of ADR. So they're perhaps thinking that their only route in resolving a dispute with their builder is to go to court. So I think there's a lot of work to be done in educating both parties, both the small builder working in the domestic sector and the clients as well, on constructive ways of dealing with a dispute situation. I hope that addresses that question, Lewis.
Yeah, absolutely. Thank you, Hayley. I think clearly there is a distinction between sort of domestic and householder construction and some of the commercial construction contracts that we often discuss. But it's really interesting to hear what the levels of awareness and understanding of the different options that are available are. I wondered at this point if I could bring in Marcus, just to give your perspective, Marcus, on some of the background to low value adjudication, and why low value adjudication might be seen as a separate category. I know that we've discussed previously, and in light of the debate during the first webinar about what adjudication was initially intended to achieve, and why that might be particularly relevant for smaller disputes.
I mean, there are certain objectives that any dispute or any business needs to obtain through the dispute resolution process. Speed, value, it's got to be effective, it's got to be seen to be effective. One of the biggest issues I think that we have in adjudication is its relative complexity in terms of its terms of the value, but also when I've served on company boards and also represented smaller companies, the issue of adjudication is that it can be seen to be a bit of a lottery, and the impact that a dispute, or particularly adjudication, has on small businesses is significant, and unfortunately it could be reputational as well. So any small firm that seems to be going to a dispute has a reputational issue. So if you move away from adjudication in terms of what it's actually trying to achieve, in terms of business continuity, maintaining cash flow, anything that can be done to simplify the process, ensure that cash flow is actually moving forward, and to recognise that even a simple or relatively simple or relatively low value adjudication has potentially a significant impact upon the employer and also the contractor. So whereas we tend to think of low values of the sub 50,000, the impact of a £50,000 or dollar turnover on a small business is absolutely crucial. So access to the adjudication procedure, a balanced approach, but also ensuring that there is sufficient resource for the adjudicator to come to a balanced and suitable decision, I think is really important, because access to adjudication or any form of ADR oils the wheels of commerce. It allows people to move on, and the impact of an adjudication or a dispute on a board or on a family business is significant. So less impact, the better it's going to be. So anything that can be done to ease that burden, ease that issue, all right, particularly on low value, and if this works consistently, then it's a real addition to construction. My only issue, and I'll probably ask Matt to pick this up on a later point, really, and possibly Peter as well, is the issue of why have we seen that a low value adjudication is necessary in terms of a mechanism, as opposed to the natural flow of an adjudication, and why isn't the natural flow of an adjudication in terms of its overall cost limited by its complexity and its value? Why is there no natural, or why is there perceived as a little natural balance? So yes, I think low value is an important tool.
Excellent, thank you, Marcus. I want to move on in a moment to some of the specific details of some of these efforts to cater to smaller disputes. Obviously, there are different models out there, as Matt has alluded to, but particularly I think we could examine the CIC procedure. But just before we do that, Peter, did you have any other comments on the background to this question and how smaller disputes need to be treated?
I think there is, without doubt, an issue in relation to smaller disputes, and there's a view, I think, that simply because it's a small dispute means it's a simple dispute, and that's not necessarily correct. And I think we have to bear in mind at all times that low value doesn't mean simple. You can have incredibly complex low value disputes. And so I think whatever we can do to educate parties and work with parties to understand how they can go about this in a better way is something that's got to be of benefit. And I'll return to that theme later on. But without doubt, we got into a situation in adjudication. I mean, I remember the first adjudication I ever did in 2000. It was about one single variation on a project, and that value of that variation was about £1,300. And that was my very first adjudication. Since then, we've moved on to multi-million pound adjudications, but that doesn't mean that the fees always have to be high. The fees can actually be managed and be kept quite low. I've very recently done an adjudication which was several £1,000,000, but my fees were less than 5,000 for that adjudication. So it is possible to do it, but it requires a lot of thinking about by the parties and by the adjudicator. So there are ways of doing this, but yes, there is a perception of a need for a low value scheme.
Excellent, thanks, Peter. I think that's a good opening point, in fact, for a bit more discussion around the CIC low value scheme, which was introduced in April last year. I think, Matt, given your position on the CIC ADR committee, it'd be useful if you could just talk us through. You've obviously already covered it to a certain extent, but if you could go into a bit more detail on the provisions of that, how the procedure aims to streamline the process, and then just talk a bit about how it's fared in the 18 months or so since it was introduced.
Yeah, okay, thank you. So in broad terms, the entry level is that you have a right to adjudicate, and the value in dispute is £50,000 or less. And then it's a matter of, you will apply to a nominating body who has a panel of adjudicators who will be appointed to manage the process and adjudicate. And then once they're appointed, they have a set of rules that prescribes the volume of submissions. So the idea is that everything should be within an A4 folder. There's a time period of 14 days for a response, a reply at 21 days, and then there's a decision on day 28, can be extended by the 14 days or longer if the parties agree. There's a facility for a meeting or a site inspection. There's a fee attached to that. But I think the starting point is the assumption that it's going to be a documents only procedure. So that, in a nutshell, and sorry, another characteristic is the fee for the adjudicator is fixed as a lump sum based on the size of the dispute, and so there's a schedule. So that at the top end, I think it is £6,000 for a £50,000. Or in the 25 to £50,000 bracket, and then that goes down to sorry, just I'll look stage right to get the exact number. It's £2,000 up to 10,000 in dispute. It's 3,500 if you're 10,001 to 25,000. So that's the sort of an overview of the process. In terms of how it's fared, the numbers of appointments that I'm aware of are I would say it's less than 150 overall for all the nominating bodies. The RICS were the busiest nominating body, and they've appointed 127 in that period. from April up to date. So when I came in, one of the first things I, as a chair of the CIC, was, how are we doing, and what can we do to increase the use if necessary? Is there anything we can do to improve the process? The feedback that we've had is that there are some teething problems surrounding, in particular, the requirement for consent or agreement for the parties to adopt the procedure. And so what you typically have is, you may have a party who wants to adjudicate, pulls the trigger, they get somebody appointed, and then you get a reluctant party to the dispute, the responding party, who says, well, why should I agree to this? And then that creates a difficulty. And there are two schools of thought as to whether or not that can undermine the whole process or not. So one school of thought is, well, providing that there's a right to adjudicate, the adjudicator could say, well, okay, I'm going to adopt this procedure as part of my powers under the scheme, for example, and I'm going to conduct this adjudication in accordance with the rules. There's another school of thought that says, well, no, hang on a minute. You've been appointed under this to adopt these set of rules, this LVD scheme, but it doesn't apply. So therefore your whole appointment is invalid. And we haven't had a test case yet. And I'd imagine that there's not many adjudicators, perhaps. I suppose it depends the view of the adjudicator. One adjudicator may say, no, I'm fine, I'm comfortable with this, I'm going to run with it. Others less so. So that is an issue that has been identified. And we've got a working group in place to see whether we can address that consent issue. So for example, the TEXA set of rules don't require consent. They say that we can adopt this as part of the procedure without consent. So that may be something that needs addressing. And I think the other point that has been made is that actually, and I've already mentioned the fees, the 2,000, the 3.5, the 6,000, that's still significant for some people, a significant sum. So, I've heard people feedback and say, well, actually, if I had a dispute, let's say it was a technical payment dispute of 50,000, and someone was telling me my fee for that is £6,000, that sounds quite high, actually. And there might be, an experienced adjudicator who could actually deal with that in half a day for a much lower sum. So it's that's something perhaps, should it be a lump sum fee or not? So TEXA is I think a capped fee. Maybe that's something we can look at, and it's certainly on the agenda in terms of things that we could do to make the scheme more accessible and used more, and also achieve what it was aiming to do, was to actually get a cost efficient method of dispute resolution for dealing with these types of disputes.
Yeah, I think you're right, Matt, that a capped approach is a better approach, because it's about minimisation. The common thread through all ADR is actually minimisation of cost. So for me, that's an essential part of it, and then value will flow from that, and then the feedback will come from that. And you're right, it's interesting in terms of what would be considered to be a compliant scheme, and on the flip side of because it's a strategy at the end of the day. Someone who doesn't want to follow a low value dispute obviously has a strategy to impose some form of commercial duress on the other party, for sure. So a quick way of avoiding that discussion would be be really, really good.
Thank you both. I think this point about party consent is a really interesting one, I think, because since since the scheme was introduced last year, I've heard from both of those schools of thoughts that you alluded to, Matt. And it would be interesting to see how that develops in terms of, you know, whether it's made clear that you don't need joint consent and that the process can be used unilaterally. We've had a few questions around that point, in fact. I mean, Timothy Lloyd, I think this question's been addressed, but is any dispute below 50k automatically decided using the LVD model, or does the referring party need to nominate it, and can the responding party object? Well, I think we've seen that yes, that is the case. Edward Carolan has also made this point, referring to a case where the responding party refused consent to use the low value procedure, and the adjudicator subsequently resigned. And Jeremy Dixon makes the point about whether the low value procedure needs to be included explicitly in standard forms of contract in order to avoid those kinds of jurisdictional challenges. I wondered if anyone had any comments on some of those questions or points.
Yeah, I mean, I think the point that Ed Carolan makes in terms of, you know, somebody resigning, you can well understand, you know, if you're a you know, sort of newly appointed practitioner, you don't want to be that test case that you know, went along with adjudication. I think, you know, it's like if you're not satisfied that you've been appointed correctly, you stop. But obviously that is inefficient. So I think anything that can be done to remove that obstacle must be a plus. The other point you mentioned, Timothy's question, then I think that the way it works at the moment is that yes, the applicant has to tick the box to say, this is an LVD dispute, so I'm applying for somebody to use these rules. And responding party, can they object? Yes, they do, and typically therein lies the problem. That's not to say they won't object in any event, but if there could be some more clarity, I think that should be a plus. The whole idea is to try and, you know, to learn from what we've experienced over the sort of the 15-month period and say, okay, what can we do now? And I think these types of issues that we're discussing, I think, need to be addressed and a revised set of rules put in place, I would suggest.
Thanks, Matt. I see, Peter, you have your hand up. I wanted to bring you in.
Yeah, I mean, I think that the problem with especially domestic cases where you've got a builder in contract with a you know, a domestic situation, a house building situation, or, you know, extension to a house situation, is that there is ultimately a dilemma here, which is that consumers are protected in law against being dragged into processes that they don't necessarily consent to, and I think this is one of the issues we have to deal with. Is again, it's about education, because ultimately it might be in the homeowner's interest to go to adjudication. They may be far better served going to adjudication than they would be going through the courts, and so it really is about education, and the time to educate is not when they enter in, when the dispute is in full flow. I mean, the time to educate is before that, so that they know what their rights are up front and can make an informed decision about it. Because, you know, quite clearly, if you're in the full flow of a dispute and someone comes along and says, I recommend this process, and they're your opponent, well, the first thing you're going to do is say no. And so, you know, people need to understand the benefits of these ADR systems, and in particular the low value systems, so that they can make a far more informed decision about whether it actually is in their benefit to do this or not, because ultimately that's a choice they can make, because both in law, in consumer law, and in the adjudication legislation, they are protected from processes that they don't wish to get involved in. So we have to, I think, work on the education side.
Yeah, I completely agree, Peter. I mean, getting access and familiarity over to what ultimately the consumers of the ADR process and Hayley's members and their clients, to inform, make it not such a hill to climb in terms of complexity, which is one of the key benefits. Preparation, so that the respondents can feel some form of control. Obviously not whole control, because you've got an adjudicator in place, but are dealing with the issues that are important to them, and additionally not sidetracked away from the crucial part of the problem, which is actually resolve the dispute and allow people to move on, which is essential, because commercially that's the most important thing. I don't know, Peter, whether or not in your experience with the FIDIC contracts, whether or not internationally, and I know that there are a number of international participants in the webinar, how that applies in terms of, for me, the application of a low value dispute internationally, particularly in places like Africa and such places, may well be a great way of bringing the dispute quickly, low value, low complexity, fast, able to be processed very quickly, enabling people to move on. I don't know whether you see that as being an application for our international colleagues.
Yeah, yes, it is. I mean, I think it's actually a matter that we're addressing in FIDIC at the moment, in as much as we are just about to launch later in the year a new small value contract, and one of the decisions we've made in that is that we are going to have an adjudication scheme in that, rather than a dispute board mechanism. So there is going to be a sort of, by definition, a simpler form of adjudication in these low value contracts once they're launched. So part of the plan is to provide what is hopefully going to be an even cheaper mechanism for dealing with the small contracts.
Sorry. Obviously, particularly in other jurisdictions, low value, taking your example, Peter, might not necessarily mean low complexity. So how that's blended is actually really important. So bringing the threads of a low value adjudication together with the application to more complex projects, for instance, might be a challenge, but the low value approach might just need that addition.
Yes, I mean, I think it is something that is always going to be a dilemma for adjudicators and dispute boards, but working on ways of trying to make the dispute resolution process as simple as possible is something that we all need to work on. I mean, I think one of the issues, and it absolutely is to the forefront in the international world, is the word dispute. I mean, we have this problem that disputes are seen as a dirty word and claims are seen as a dirty word, whereas they are predominantly just part of the process. And if we can move away and educate again away from people seeing the word dispute as a dreadful situation, and accept that it's the very nature of building and construction, then we may be able to move forward. But it's all part of this process, I think.
Yeah, I mean, completely agree. I mean, when I've sat on boards of directors and we do have a dispute which occurs, the very word adjudication causes a shudder through the business, and at board level it's not seen as being a minor issue, because of the legal context that it has, particularly in construction, and therefore it diverts attention away from the normal running of the business, and that communication to say is part of the process. It is a tool, just as we have the other ADR tools, in order to resolve these issues quickly. And if we can focus, or if the message focuses to members on saying, you know, this is about quick, decent, reliable decision making to allow people to move on, the more we promote that as a message, the easier I think it's going to be for application. And I think internationally, that's really an important message, because it does have a massive impact at the board level.
Yeah, and on that theme, I mean, one of the things we're trying to do is have the dispute board, its focus to be on dispute avoidance rather than on actually resolving disputes. And if we can focus on dispute avoidance, then that is a way of moving that forward, and you know, demonstrating that there are more issues here than simply disputes being a dirty word. There are disputes there. They come about by the necessity and the nature of construction, and we need to find a way of managing those in an appropriate level, and that is something that I think that, you know, we always need to just keep educating and trying to improve our understanding of these processes.
Thanks, everyone. I think this is an important point as well, around offering different options that are tailored to the particular type and level of dispute. And I wanted to bring Hayley in here, because there's been quite a bit of discussion around the potential for low value adjudication, particularly to apply to perhaps domestic construction contracts where statutory adjudication wouldn't necessarily apply. I know, Hayley, you spoke about obviously some of the FMB standard contracts, and there are lots of other standard contracts where the dispute clauses would cover mediation, arbitration, and I wonder whether you see a role for a low value adjudication process applying in that, because it's something that a couple of our audience members have alluded to.
Yeah, thanks, Lewis. So actually, I'm finding this discussion very interesting and informative myself, because it's making me reflect on the way that we try and funnel all of the cases that we receive on behalf of our members down the mediation route, and that probably isn't always the best answer. And part of the reason that we do that is because there is a perception that adjudication is going to be expensive. There's also a worry about loss of control, that somebody else is going to come in and make a decision that you're not necessarily going to be in agreement with. Whereas one of the kind of selling points that we use to encourage members to participate in our mediation process is that you will stay in control, and whatever the agreement is reached, you'll be part of that. But what that sometimes does is lengthen the process, because the parties can't agree, and actually having somebody else come in as a third party to make a decision might be exactly what they need to get that resolved and to move on, because we know the cost to businesses is enormous in terms of the time that it diverts away from the work that they should be doing on their building projects to resolving a dispute. And we're also seeing increasing numbers of disputes at the moment. In fact, it's kind of our monthly dispute case level has doubled over the past few months. And that's partly because of the increasing costs of building materials, which are having an impact on the contracts, and skill shortages, so shortages of skilled subcontractors and workers, which are also causing delays and potentially problems with quality of the work in some situations. So I think it's important that we give our members access and better understanding of their options in resolving a dispute at this point in time, because we're only going to see these issues continue to escalate, I believe.
I think the other thing as well, Hayley, is that something I've learned from working abroad is that the dispute needs to be, the parties need to be satisfied after the dispute, so that so that they don't exactly have a great feeling about having gone through the process, but they feel that they have a satisfactory, if not ideal, resolution. Because if you can achieve that with whatever process that you're using in ADR, what you will get is you will get more use. The use of ADR adjudication will be promoted, that you will get more harmonization, you will get more retention of relationships through that process. And if that can be focused on as well in terms of that ultimate development, I think you'll find that the Federation of Master Builders will actually benefit, on all organisations promoting this benefit. And if low value dispute resolution mechanisms such as this add to that, it's got to be a positive, Matt, hasn't it, in terms of that ultimate satisfaction?
Yeah, I think, I mean, it was interesting listening to Hayley, and I couldn't help but think of Brexit and the effect it's having. And one of the effects of Brexit might be positive, and perhaps I'm betraying what my betraying what my feelings about the whole Brexit situation is, but I don't want to offend half of the audience. But one of the positives may well be the reintroduction of the FMB adjudication scheme that we used to have, but the EU legislation said that it was actually too expensive for a consumer scheme. And it did make me think, well, actually we had a scheme where I think it was £1,100 maximum fee for an adjudication. It was 21 days. It wasn't a statutory compliance scheme because it was a consumer. It was effectively the FMB's complaints handling procedure where there was an issue between a consumer and the FMB member. And I can remember being involved with some of the pilots. I mean, they were horrible to do in terms of an adjudicator, but actually, the skill set required was certainly at the higher end in terms of case management skills, because you were having to deal with a multitude of issues with a relatively modest sum in dispute, but you were giving them an answer which was effectively allowing them to get on. And I mean, I've heard, I think Lord Justice Coulson, I think in the Court of Appeal, has already said that he thinks the residential owner occupier exemption from a right to adjudicate should be lifted. I don't necessarily subscribe to that, but I do think that perhaps the time for keeping those types of disputes away from the court that may actually have a higher cost has a certain attraction. And if we think about the consultation that's going on at the moment with ADR and compulsory mediation, question mark, and again a debate of whether that's a good or a bad thing. I wonder whether the time is right, perhaps, for the FMB perhaps to consider an adjudication process for those situations where you can't get this consent to mediate, and perhaps, if somebody doesn't want to agree, then they're not going to agree to anything, perhaps. And actually mediation adds expense when you haven't got people there who really do want to settle. Some people do actually need an answer to be imposed upon them.
Can I be controversial, Matt?
Yeah, always.
Trying to link satisfaction and knowing the parties that are involved in low value disputes. Adjudication boils everything down into essentially a financial award, doesn't it? And Peter said about the potential ability of FIDIC to introduce adjudication, and then linking satisfaction to adjudication, realizing that it's not always satisfaction doesn't always come down from a financial exchange. It may come down to the exchange of a duty or an obligation, or a release of obligation, or perhaps taking a very simple thing, an obligation to to repair or to offset something, and whether or not that an FMB solution or a FIDIC solution, all right, particularly internationally, should blend, or potentially have the ability as a mechanism to blend adjudication in terms of a commercial settlement, but also a solution settlement to get that satisfaction.
I think for me, mediation, I'm a great fan. I think it works. There are certain situations where, and I've certainly seen it, where I just get the impression the parties are only there because they've had to tick a box because the court are going to penalise them in courts if they don't, and it's an expensive day, because you just need to do, work out the hourly rates of all the people who were there, and you think, well, actually, maybe they would be better spent articulating their position to somebody else who gives them an answer that they can move on with. And I guess maybe it's allied to what Peter said about, if we can get away from dispute being a dirty word and think of resolution as it's inevitable that people will disagree, and that we can assist with that to enable the parties to move on by somebody that the parties respect, and they'll live with that outcome, or they have an option. And I guess one of the characteristics perhaps of the low value disputes is that, one of the benefits of adjudication, i.e. it's temporarily final, is that if somebody doesn't live with it, they can always arbitrate and or litigate. Well, in a low value, they probably, unless they've got very deep pockets, they probably don't have that option. So adjudication is more likely than not to be the final outcome. So I think there's a requirement for the quality to be good, and for something that gives the parties not necessarily a bitter taste, but saying, well, okay, I might have lost, I respect the decision, but it's not, it's not giving me a bitter taste in terms of the expense of going through that process.
Do you think, Peter, that blend could be achieved with a settlement agreement that incorporates adjudication? I mean, think about the FIDIC, or what might be happening in FIDIC, whether or not a blended approach might have benefits.
I think there is a room for a blended approach. I mean, if you look at the standard FIDIC model of a dispute board now, part of that role, and a main part of that role, is dispute avoidance, and we can do dispute avoidance by many ways. I mean, I do dispute avoidance every time I go on a site visit by asking carefully crafted questions that, when the parties think about those questions and think about how to answer those questions, they realize that I'm taking them down a certain track and trying to get them to think about ways of dealing with this potential dispute. You can also deal with that by mediation if the parties so wish. So, I mean, I think that there are the tools there in big contracts, without doubt, to allow this sort of blended approach. And if you talk to most parties in big FIDIC contracts internationally, they basically use the dispute board as, we've won 3, they've won 4, let's bring them all together and do a deal, and that tends to work. But then you're dealing invariably with commercial parties. The difficulty, I think, in low value disputes predominantly is you move away from that commercial aspect, where people can just see it as, well, it's part of the commercial reality is that we have to go through a dispute and adjudication, and it gets emotionally attached. This is my house, they've done that to my dining room, that's the sort of issues that come up, and those are very difficult to actually deal with in a sort of blended approach, unless there's a great deal of willingness by the parties. And again, as I keep saying, I think that willingness comes down to education and making informed choices.
I just wonder that almost the conciliation process might be more suited. So actually you have if you think of conciliation, where you'd have an attempt at mediation, and if they don't resolve it, you then get a recommendation from an experienced professional. Maybe that might be a model of getting the best of both or the best of both worlds. So the part of the exploration is the mediation. So that time if there's not a resolution is not wasted, because you're informing the decision maker or the recommender to actually say, okay, well, here's my recommendation to the parties, and yeah, maybe that, yeah.
That's something. Sorry, Matt. We do offer that to some participants in our scheme. So we have access to a panel of conciliators, and in some cases they can make recommendations. So that does happen occasionally. What we find though, and I think it was Marcus who made the point earlier about the satisfaction afterwards and feeling like the dispute actually has been resolved. And when we did our survey in March, we found that about 40% of consumers who'd been through our process didn't feel that they'd reached a fair resolution. But we thought that they had. We closed the file on that case where, you know, both parties had agreed on something. But what we were finding was sometimes an agreement is reached in writing, but the agreement that's been made doesn't actually happen in practice. So the builder may have agreed to rectify something or provide some certification that's missing or whatever it might be. And they agree to that, but then for some reason it doesn't actually happen. But I think what happens in some cases is the consumer just gives up because they've spent a lot of time going through all of this process already and they're not prepared to invest any more in it. So I think that's a weakness in our scheme that, you know, obviously we want people to feel like we've devoted a great deal of time and resource to helping them resolve their dispute, and we want to feel that that's what's happened at the end of it. And also is a completely separate issue, but what often happens at that point is the clients take to social media and will trash the builder's reputation and also the FMB's reputation because we haven't helped them to resolve their dispute as they see it. And I should add at this point that, you know, we're talking about sort of less than 1% of the jobs that our members carry out in any one year that end up as being part of this scheme. But that's still quite a big volume of cases for us to deal with because we have a fairly large number of members. So I think that social media has kind of been weaponized as part of this dispute process. And almost in some cases, you can see that the consumer's kind of blackmailing their builder to say, if you don't agree to what I see as a fair settlement, then I'll be on Facebook telling everybody that you're a completely useless builder. So I know that that is built into a lot of the recommendations and the outcome statements that get signed. That is something that's part of that they will refrain from defamatory comments on social media.
It's one of the
reputational again, isn't it, Hayley, in terms of the preservation reputation, and obviously mediation is ideal for that. But as Matt said, it just simply might not be appropriate. And we also have to be careful with mediation, and when comparing the two, that obviously mediation can be seen as being a way of officially obtaining a discount. And that's, I think, at the top of everybody's mind. I don't know whether there's a blended mediation adjudication route, Matt, that needs to be formed. But
yeah, I think that, to be fair, I think the conciliation can work. I mean, it's very popular in Ireland, and on public sector contracts, and one of the reasons for that, I perceive, is because of the fact that it's a relatively small market and a small community. And so for the public sector contractors, generally, the government or their entities, and a relatively small number of contractors. So there was a desire to have, preserve the relationship. So the conciliation, the mediation part might work. But the other reason it worked was that because perhaps a public sector organisation that maybe struggles to make a decision or takes responsibility for it is more able to live with a conciliator's recommendation, because then they can report back to committee and say, well, look, we tried to mediate, we didn't get an answer, or we couldn't get a resolution, but now we've got a recommendation from an experienced conciliator, and therefore we as a committee we should sign up for that. We're happy to live with that. So maybe where you've got that sort of desire to preserve relationships, but also live with an answer and move on, it might be able to work.
Matt, how much do you think, not necessarily reputation, but competence of the adjudicator in these small value disputes, how much do you think that contributes in terms of satisfaction?
Yeah, well, I think it's key. I think, yeah, there's no doubt in my mind that the case management skills required for a low value dispute and a potentially expensive process are of a higher need than they are when the number in dispute is large, because I think time and money are related, and so if people are going to agree to extend and put in further submissions, that's going to increase the cost. And if you've not got experience of having to deal with that, or the confidence to be able to deal with that, that can have an impact on the cost of the process. And I'm looking at the parties' costs here. So what you do, you might not necessarily be aware of the impact that's having on the party. So when you're asking someone to do something or make themselves available or have a meeting, and then you look at everybody around the room, because you're protected to a certain degree from the costs, you don't necessarily understand the effect of what your case management decisions are having. And so I think that I know that there's one perception perhaps is that low value disputes are the entry level, if you like, for the adjudicators. And I get that to a certain point, but I think that perhaps if there was some joined up thinking to say, well, okay, let's have, yes, it may be an opportunity for people to learn their trade, but perhaps with a mentor of an experienced hand to be able to say, hang on a minute, just, maybe have you thought of this? And so I think that, don't sort of be under the impression that just because it's low value, it's not complex. It's a case of perhaps if we've got people who can guide, then we might actually sort of get the best of both worlds.
So allied to that, Matt, and perhaps Hayley as well, actually, the competence and the experience technically of an adjudicator. For instance, that if an adjudicator was selected on the basis of their background, their experience and their expertise in a particular technical point, for instance, do you think that might help in terms of people feeling that they got more satisfaction? So if you will make that information available.
Yes, I would think that would at least feel encourage people to feel like they'd had a fair hearing by somebody who understood the issues. But then that could potentially increase cost as well.
Yeah, I mean, potentially it could. I mean, but I mean, a lot of our, I suppose, a lot of our members and our adjudicators have specialist knowledge that would theoretically increase the efficiency. Case management, as Matt says, is really important, but also that background might ease the fluidity of the decisions that need to be made. I don't know what you think about that, Peter.
I mean, I think one of the big issues for me, I think about certainly low value adjudication, and especially with domestic adjudications, is technical skills are just one level. You know, the technical ability and competence should be a given without any thought whatsoever. The real issue, I think, with dealing with domestic ones is giving that consumer the opportunity to be heard, even if what they're talking technically and contractually is of no value in the outcome. What they want is to be heard, and I think adjudicators and mediators have to have that skill that allows them to take the consumer with them, because that to me is one of the most important things. If you're going to resolve this dispute, and then back to what you were saying earlier, you want the parties to come out of this feeling satisfied. Well, part of that is that the consumer comes out of this feeling as if they've been heard and listened to. I mean, it was a message that came over to me a long time ago, when we used to have court annexed adjudication back in the early 2000s. I spent sort of 3 hours on this mediation between two parties, and I thought I was making progress, and I thought I was getting this the parties closer and closer together. And then after about 2.5 hours, the consumer turned to me and said, right, we've done this mediation now. Can we get on with the litigation, please? And I thought, well, I've just wasted, all my time. And it brought home to me loud and clear that you have to make sure at all stages of this process that the consumer is brought along and knows where they're going and feels as if they're a part of the process, rather than having this process thrust upon them.
Thank you, Peter, and thanks everybody. I think that's been a really illuminating part of the discussion, and I'm glad that we've actually branched out into the question of other dispute resolution mechanisms that might be available, because I think it needs to be looked at holistically here, particularly in light of what the main objectives of the parties are in any given scenario. As Hayley alluded to, sometimes that sense of control over the process and the outcome that can be gained through mediation is paramount. For others, they want a quick, enforceable decision as soon as possible. I just wanted to say, because I'm conscious that we've got limited time left, and I know that we could keep talking about this all day, but there's been some fantastic questions coming through. There was a comment here from Neil Watson, and I wondered if I could get the panelists' thoughts on this. It really touches on something that came up in our first webinar back in July as well, around what adjudication was initially intended to achieve. And Neil has said here that adjudication was originally established to quickly resolve relatively low value construction disputes. It's since become the preserve of multi-million-pound construction contracts involving teams of witnesses and lawyers on both sides, and that all adds to the cost. Neil believes there should be a move to re-establish a mechanism for short, sharp, low-value adjudications. This should not need any change in legislation, but does need a refocus from AMBs. Now, I think we've touched upon that with the CIC low-value procedure, but in line with the title of this webinar, what do the panelists think the AMBs in particular can do to push the low-value procedure? And how can we educate parties and others to try and streamline the process further? We've talked a lot about awareness raising and education, but I just wondered if we could delve into that a bit more before covering some of the other questions.
Do you want me to start?
Oh, go on.
That would be go ahead, Marcus. Thanks.
I mean, Peter raised the issue of education. It's got to be primary, because it not only opens the gateway to dispute resolution, makes people feel comfortable with the process, but they also have to feel comfortable through the whole of the process, right the way through. And with that comes familiarization, and not trying to then second guess, where do I go from here? So it's a little bit more in terms of, I think that confidence is required, education is required. And to be honest, anything that we can do in terms of case management as well, because as adjudicators, we've all received, and I'll be interested to see whether or not, Matt, in your 800 adjudications, at what percentage raises your eyebrows and shakes your head and go, well, what have I got to do with all this? I can't even find everything. But simple things like that will reduce the overall cost. But I don't think it's done with malice in terms of the parties. It's just that they are doing things that they think is the right thing. And maybe if they were made aware of how to make the adjudicators' job easier, then that might be, you know, a positive step as well, because it's the churning of the information that for me is the big issue. But then, in terms of satisfaction, in terms of, we tend to compartmentalise the dispute resolution, I think, just generally, particularly in the UK. And I'm a bit of a fan of a blended approach. I'm a bit of a fan of using ADR as a bit of a Swiss Army knife of tools to resolve disputes. Because if you're sitting above 5 or 6 large construction projects that are going through your books, what you want to do is you want to be aware that you can move to mediation if that mediation is okay to do. You can move to adjudication. Some things need litigation. It's using the appropriate tool in order to get the best result, the most efficient result. And for me, general knowledge about adjudication and all of dispute resolution, the education that goes with that, and as Peter quite rightly says, making dispute not a dirty word, but part of the process, because there's always going to be problems. There are always going to be risk that hasn't been anticipated, and assumptions that have been made. So why not encourage people to not necessarily pursue it, but to embrace it and not feel afraid of it? And maybe that's one of the ways of moving it forward.
Yeah, it's interesting. I recall, when I did have those situations, in terms of what I detected was perhaps an uninformed or unfamiliar party, I would always send them the CIC user's guide to adjudication to say, well, here's something. So, because I guess you could educate the parties, but the 95% of them hopefully don't need it to ever use their dispute resolution awareness. So I guess there's a balance. Are you telling me a busy small construction business, relatively low turnover construction business, are they going to have the interest to learn about adjudication and what's available to them? I would suggest not. When they have a problem, then it's, well, who do I go to? And I think either perhaps maybe if they're a member of the FMB, they might be able to go to the FMB and they'll say, well, okay, well, here's some information. I think as an adjudicator, if you've got access to, you can't give advice, but you can say, well, look, here's a user's guide, and then there might be the sort of the lights come on and like, oh, okay, I realise now, and I think that's been helpful in terms of informing the parties, but it's almost a bit late in the process. I think the education isn't just linked to the parties, although it has a significant part to play. I think education of the adjudicator to deal with these types of disputes, and I certainly remember with the FMB scheme, there were experienced adjudicators, but they said, well, we need to do a day to inform you about the types of issues that you may have to deal with in terms of the types of contracts and the types of disputes that you may have to deal with, and it's a certain skill set. So I think education for the dispute resolver, as well as having some sort of independent guidance that we can use on to share with the user, so that they can say, well, okay, and actually getting that connection with what you do may have an effect on the cost. If you can marshal your evidence in a certain way, page numbers, simple things, page numbers, paragraph numbers, respond to what's been put, that could help.
I mean, right at the root of the dispute, Hayley, it might well be that one thing that you could do is to have a toolbox that is available to the consumer and to the contractor, that lays out a pathway and contains what Matt says as a toolbox, how to make the adjudicators or mediators or arbitrators or whatever their life easier. and maybe that's one way of enabling that, as is direction on where parties can ask for assistance and help. I'm a big fan of Amazon in terms of you get 3 clicks and you can get to whatever you want. I'm not suggesting that Amazon go into the provision of adjudicators, because they might be a bit tricky, but being able to get quick access to the information and the people that you need in order to resolve your dispute, I think is a key thing again.
I think one of the other things, Marcus, is I think especially for the slightly more aware and in particular contractors, less so consumers, but it would really help consumers if they were aware of it, is being strategic about your adjudications and what issues you refer. I mean, I remember representing a party who had literally hundreds of variations in dispute. And rather than referring those hundreds of variations to one adjudicator, you know, from everything from £10,000 to a £16.38 variation, we just picked 1 or 2 very, very specific issues that were typical of the dispute. We referred those to adjudication. We got the result we wanted, and then we went to the other party and said, look, we can do this 10,000 times, or we can sit around the table and do a deal, and that worked. And being strategic about it is one of the ways of keeping the costs down, because the thing that me and Matt hate more than anything else is when you get absolutely everything referred to you, including the variation that is valued at £16.38, and the other side says it's worth 3 and 4, and you end up in sitting there going, how on earth am I supposed to deal with that variation in a cost-effective way? Even if you should be dealing with it, it really is. We can do this in a lot more strategic way if the parties think about what it is they want to refer to adjudication before starting adjudication. So there are many, many ways in which the parties can help themselves to keep the cost of adjudication down, and they don't have to refer everything. They can choose specific issues and just refer those and see how it goes. So that there are many tools available to the parties to help themselves, if they are aware. But it's making sure that parties get to that point where they understand these choices at the appropriate time, because without doubt, when you get into the middle of the dispute, the parties want to throw in everything, including the kitchen sink, including he said, she said, and all the rest of it, whereas it may not be in anyone's interest to deal with those issues. So thinking about what gets referred to adjudication is an equally important part of dealing with the cost of adjudication.
Do you think that generally there is a space for some form of case management review prior to the adjudication? I mean, Matt highlighted the issue of the importance of case management. We've all been recipients of the kitchen sink adjudications for the final accounts, where somebody just said, well, I just can't be bothered to do it, so I'm just going to give the 648 items in my long list to the adjudicator, which I think is bad, down to poor commercial directors, to be honest with you. That's another story. But do you think that there's something there in terms of allowing the adjudicator maybe to help with the case management?
Yes, I do. I mean, I think one of the things, as adjudicators, we always dread is you say, yes, I'm available to an adjudication. You don't know whether that's going to be 10 pages of A4 or 48 lever arch files or a lorry load of lever arch files. And so you say yes, and then you find out what it is thereafter. So if there was a mechanism of between saying yes, I'm available, to receiving the referral, to have some sort of case management input, I think there is definitely a opportunity there for the adjudicator take control at that stage, because we're not in control at that point. The problem at the moment is you say yes, and then the referral comes, and the referral to some extent casts the die. And all right, the response can cast it as well, but that referral from the party that you've had no input into, no ability to see what's coming, it is what sets the scene. And all right, adjudicators thereafter manage, but we manage what's been referred to us. So if there was an opportunity to actually get into some dialogue with the parties prior to the referral coming, then that could be a useful step. Yes.
Yeah, I think
sorry, you're talking about almost a sort of triage system of looking at the case before it's referred to an adjudicator, which sounds like a very good idea. And in our case, that would be looking at what is the best option for resolving this dispute that you've got. I do wonder, in the light of the ADR consultation that's going on and potential mandatory ADR coming in 2022, whether there are enough people with enough relevant experience, training and knowledge out there in the sector to do all of this work, because we're CTSI certified in terms of what we do with mediation, but many trade bodies out there offer informal mediation to their members. Some of them are regulated and audited and some of them are not. So they're probably all doing it in different ways to different standards. So whether we can cope with this increase of ADR cases collectively as an industry, I would have a question mark over. And I think when it comes to the education piece that you were speaking about as well, I think it does need to start earlier than when the dispute has already arisen. And for example, Peter, you were talking about variations. We've run a series of webinars for our members on dealing with variations and trying to avoid the dispute by communicating early with the client about those variations and the impact of them. And we hope that that's having an impact out there with our members doing that, effectively, but it's quite hard to measure. And I would also think that there's something about the terminology around all of this that is off-putting to the small builder and the domestic client. So, all of these loads of words are loaded, like dispute, as we've already mentioned, is a loaded word in itself. But things like a conciliator, an adjudicator, all of that terminology is unfamiliar with certainly our members and the domestic clients. And maybe if we could inject some more plain English words like dealing with a disagreement in a fair way to reach a sort of equitable outcome. I don't have the answer to that, but I think there needs to be something that doesn't immediately raise the hackles of your average small builder who, as soon as you mention adjudication or mediation or anything, thinks, well, it's all to do with legal and it's all going to involve solicitors and cost loads of money. And I think that is the perception.
And I think you're actually right, Hayley. To a certain extent, contemporaneously, NEC obviously dealt with the simplicity of language, but also new terminology such as compensation event rather than variation. So it is something I think that's actually evolving, and that's a really interesting point. Maybe it is something that we need to address to avoid the moniker of dispute. Lewis, perhaps that's something that you can look at.
I think it's a really interesting point, Hayley, and I think we've had some good feedback in the chat from the audience about that point. It is also something that CIARB, as a professional body for all forms of dispute resolution, it's a challenge that we see all the time, which is how do you communicate often quite technical and niche mechanisms for resolving disputes in a way that's comprehensible to the end users, because I think ultimately that has to be key, and that's particularly important, I think, at the lower end of the spectrum with lower value disputes, because if we're talking multi-million-pound disputes, there are normally teams of lawyers. There may be other issues with understanding perhaps at that, but it's not normally around the technicalities. So I think that's a really interesting point. I'm conscious that we're approaching the last 5 minutes now, so I wanted to just go around the table, as it were, and ask you each, firstly, if you've got any sort of final words or closing remarks that you wanted to make, but also if you think there's one thing that adjudicating and nominating bodies and perhaps trade bodies like the FMB could do to try and improve access and understanding in the marketplace around adjudication, but also the wider dispute resolution framework as well. Hayley, if we kick off with you for that.
Okay, yeah, it's been a really interesting discussion, and it's made me think that perhaps we ought to be widening the range of different alternative dispute resolution methods that we're referring our members to, depending on the type of dispute that we've got. So that's something that I will take back. And also, I think this is a good time to be thinking about these issues because, as I said, the number of dispute cases coming into us is rising. I don't know if generally across the piece people are experiencing more disputes, but I think that thinking about the terminology is a really important piece of work, actually. I mean, even if you think about it, the low value name, if I've just spent my life savings on an extension or a loft conversion, that's not low value to me, even though in the scheme of things it may be. And is that putting people off from using the scheme because they think, no, this isn't a low value dispute, it's a high value dispute to me because that represents my life savings or a massive loan I've just taken out. So yeah, I think there's all sorts of issues coming out of this discussion for me that I'll take back to the FOB to give further thought to.
Excellent, thank you, Hayley. Peter.
Yeah, I mean, I think there are a lot of issues where certainly trade bodies and institutions can do more to. I keep using the word educate, but just provide the information about what the toolbox is and what the options are, because I think if people understand better these tools that are available to them, they can decide themselves which ones are appropriate. I mean, you know, you've got adjudication, mediation, but you've got lots of things that we do in dispute avoidance where, you know, you're not talking about adjudicating. You're looking at ways of working with parties to try and get them to work out the answer to the dispute themselves. You know, I do that an awful lot in you know, what I do with FIDIC and on other big international contracts. I spend an awful lot of my time working with parties to avoid disputes rather than resolve disputes. You know, I've often said that as far as I'm concerned, I think I failed if I'm on a dispute board and I end up actually adjudicating, because you know, ideally I'd like to avoid these disputes. So there are, you know, terminology and an explanation of the tools available to the parties and sort of a place they can go for information so that they can get that information when they need it is, to me, one of the things I think we really ought to be working on.
Absolutely, thank you. Thank you, Peter. Marcus, did you have any final words you wanted to?
I support Peter in wholeheartedly in the issue of education for all the parties. It has to be the conduit to open up. I think the more people understand that disputes and disagreements in particular construction are a normal part of a complex procedure, the more that we can get that across, but also that we provide the solutions, that we have the right caliber of individuals, and they are out there, Hayley. There's a lot of people that are looking on now. There's a lot of good people in a lot of organisations, very professional in terms of what they can do to resolve disputes. The flexibility of approach to narrow the issues, to not waste time on periphery, but get to the nub of the problem to get early satisfaction, is again something that is really important. And any process that allows us to get to a more efficient, more cost-effective quick methodology of getting satisfaction, however it comes about, has got to be there. And if we stop compartmentalizing the way we look at disputes and blend the tools that we have at our disposal, I think the better it will be.
Absolutely. I think that complementarity, Marcus, is something even beyond just construction disputes is really, really key, and something that the Institute is closely engaged with. Matt, just to give you the final word.
Thank you. I've got two things quickly. One, I think, is collaboration between the different professional bodies and nominating bodies, and that's something I've been encouraging. And I want more people to the table to share experiences and knowledge, so that we can actually come up with something that serves the industry, and I think that's key. The other thing I think was, one of the significant part of the cost of adjudication is the cost of the parties that they incur putting their cases. The CIC procedure attempts to give the adjudicator confidence, because there's this tension with breach of natural justice and fairness, because if you don't allow people to have a final word, but actually gives them a bit more confidence. Say, well, no, the rules say this. You've got 1 or 2 chances of putting your case, and a limit. I think that can add to the cost efficiency of the process. So basically giving the adjudicator the tools to say, I'm going to put a limit on what you can say and how many times you can say it.
Excellent. Thank you, Matt. Well, thank you everyone for what I think has been a really, really fascinating discussion. The audience questions have been really fantastic. I'm sorry that we couldn't get to everyone, and I'm conscious that we also could have kept this discussion going all morning, really, but we're sadly out of time. I also want to thank our audience for joining, and I would like to invite you all to join us for our next event in this series, which will be held on the 22nd of September at 9:30. And this will be explicitly looking at adjudication principles and whether they can be used beyond construction. So you can see here now, this is the title, Beyond Construction, Can Adjudication Be Used More Widely as a Mechanism for Resolving Disputes? You can register for that now online. I hope to see a lot of you there, and thank you once again for joining. It's been great to see you all. Thank you.